Welcome to Heartbreak and Hope with Pat Barbarito, the show that explores how to build up or break down any relationship with confidence, clarity, and compassion. Financial responsibility. Yeah, not exactly a sexy topic. We get it. And you might be wondering why we're tackling this topic on Heartbreak and Hope. But here's the thing. I've learned a lot in 40 years of being a divorce lawyer. And something I've really learned is that financial responsibility, money, it matters. Understanding finances, it could intensify heartbreak. And boy, it could encourage hope. Now, I know this might feel like a lot of details and a lot of information you don't want, but I promise you, this should be housekeeping 101 when you're thinking about getting married or when you're getting divorced. And I don't mean just having money in the bank or having a good job. I mean being financially aware, being able to plan. And that leads me to introduce today's guest. Gary Botwinick is interesting, smart, and unique, especially for a estate tax trust lawyer. I admit I'm a little bit prejudiced. Gary Botwinick has been my business partner for almost 25 years, and we manage our law firm together. However, the truth is, I've never met somebody that has this really unique ability to balance an extraordinary understanding of financial responsibilities, estate planning, tax issues, and balance that with the complex understanding of human nature and needs. Gary is chair of our Wills, Trusts, Estate, and Tax Department, and I know it's hard to believe there's such a thing as a rock star in that world, but there is, and Gary is one. So if you're thinking that, oh God, this guy just does wills and prepares boring documents, well, he does do that too. But there's a lot more to this. Gary, you're an estate, trust, and tax lawyer. Why would somebody come to see you? For what issues and when?
Well, certainly for estate planning, meaning making sure their affairs are in order in the event of their disability or their death. But also in the event of an upcoming marriage, they might come to me to talk about putting together a prenuptial agreement because they have assets they want to protect for one reason or another. Maybe it's a blended family and they wanted to make sure they protect their children from their first marriage. Or maybe it's a young family first marriage. One of the spouses comes to the marriage with accumulated wealth, inherited wealth, significant professional accomplishments, and they want to ensure that they protect their own assets in the event the marriage does not last.
You always say marriages end in one of two ways, but they always end. So tell the audience, how do marriages end?
It came to me a while ago that when I was doing this sort of planning that marriages end in one of two ways. Either they end as a result of a divorce or they end at death. And death is inevitable. So in the event that you manage to stay married for your entire lifetime, then we do need to be concerned about the issues that occur with the death of a spouse or the death of both spouses.
Well, that's kind of depressing, isn't it? Especially, if you're a younger couple and you're getting married. I never really thought about it like that. This is going to be over one day. But when you have a younger couple or a client who's first time marriage, maybe 30 years old, and they're getting married and they come to speak with you, do you have a conversation with them about the inevitable ends and what tools are available to them to address that?
So while certainly we deal with young couples, young spouses in connection with the estate planning process, oftentimes one of the first connections I have with a member of a future marriage is in discussions regarding the upcoming nuptials and how a prenuptial agreement might fit into the plan, the marriage, and the upcoming event.
Isn't that depressing? Like, oh, it's going to be over. Might as well plan the end now.
Yeah, I suppose so. But look, I'm a planner. I'm an estate planner. I work with clients on business succession planning. I think it's always important to plan. And it's inevitable, as I said, that this marriage is going to end in one of two ways. So we have to be aware that a marriage may not work out. You need to understand when you're going in, what are the consequences of when the marriage does go south.
So let's talk about in the prenuptial, do you address divorce and death?
I think that every prenuptial should address both of those issues. It's fascinating. I still see from time to time many prenuptial agreements drafted by attorneys, primarily by family law attorneys, where they focus exclusively on the event of divorce. But in many cases, you have blended families, couples that are coming together where they have children from a prior marriage. And if you're just addressing what happens in the event of a divorce, there's a good likelihood that you're going to mess things up, because the greater likelihood in a second marriage is that it will last to the end. And you do need to address the issues of what happens when one spouse dies.
Let's start with the divorce part, because that's the heartbreak part, right? So couple's getting married and she comes in, she's a professional, has a little bit of money saved. Do you recommend a prenuptial agreement? Because to me, it seems, I don't know, like I have no faith in this. Do you say, let's talk about your divorce?
Well, prenuptial agreements are pretty rare. I don't know what the statistical percentage is of marriages that contain a prenuptial agreement, especially among young people. In many cases, young people come to a marriage with little or nothing, just starting their lives. But marriages are occurring later in life over the last several decades. And it's not unusual for a young couple in their 30s to have either accumulated wealth from an inheritance or a gift. They might have an interest in a family business. They likely have achieved some success in their professional world and maybe have a reputation that has value. They may very well have accumulated significant wealth during the marriage, during the time between maybe graduating college and the time they're getting married.
So what does a prenuptial do? Doesn't a divorce take care of all that? Why do you need a prenuptial agreement?
Well, divorce will certainly take care of that, but not necessarily in the way that would be in the best interest of the spouse who has most of the money. For example, if you have a young professional who has accumulated, let's say, $1 million 401k, and maybe they have some stock options or restricted stock or some other employee benefit that they are bringing to the marriage. They possess these before the marriage. One of the goals ought to be to protect those in the event the marriage doesn't work out, that those assets that you're bringing to the marriage should remain the asset of the one who brought them to the marriage in the event the marriage doesn't work.
So if you don't address death in the prenuptial agreement, does the law address that, or could a will address it?
Yeah, so certainly shifting gears when we're talking about in the event of a death, once you get married, there are certain rights and obligations that one spouse owes to another.
Under the law, just in general?
Under the law, by statute. Typically, there are what we call forced inheritance laws, which are sometimes called elective shares, where you can't simply disinherit your spouse. For example, I practice primarily in New Jersey. So if I have a client who wants to disinherit his or her spouse, and they draft a will and take care of beneficiary designations and other documents and get their affairs in order and leave everything to somebody other than their spouse, and they're still married at the time of the death, the spouse does have a right to elect against that will. In other words, challenge the will to the extent that they're not getting what they're entitled to, because the New Jersey legislature has said you've got to leave a minimum amount to your surviving spouse. And if you don't do that, the surviving spouse has a cause of action and can bring an action to get what they're entitled to.
So in the prenuptial agreement, could you could you waive your right to that forced inheritance or that elective share?
You absolutely could, and oftentimes that's what we do. So where a couple is coming to a marriage and one or both parties want to be free of this obligation, in other words, let's say they've got children from a prior marriage and they want to make sure that the assets that they're leaving ultimately go to the child of that prior marriage and not to the surviving spouse, ultimately go to the surviving spouse's new husband or children. The prenuptial agreement will address that by saying that there would likely be a waiver of this, what we call elective share statute in New Jersey, or this forced inheritance.
But you raised something very interesting. Isn't it really the couple that's getting married for the second or third time with grown children? Isn't that really where prenuptial agreements are the most valuable?
It's far more likely that you would see them in those situations, but there are other circumstances. For example, let's say that a groom comes to me and he has inherited a family business, or he has been given through estate planning process an interest in a family business, and that has significant value. And it's the parent's wishes, the parent of the groom, that business stay in the family. It may very well be that the prenuptial agreement will provide that the surviving spouse, the bride in my example, is not entitled to the interest in the family business, and that has to go to any children that might be born in the marriage. And in the event there are no children, it's very possible that the parents who had made that gift might want that to revert to other children or other grandchildren.
Have you seen situations where the preparation of a prenuptial agreement leads to people not getting married? I have. I've seen it becomes so contentious that one party or the other says, why am I marrying this person? Have you had that experience?
I have, and I've had them with you.
Let's talk about some of them without mentioning anything in particular.
It's unfortunate that sometimes that happens. I would say that's more of the exception than the rule. In most cases, prenuptial agreements that are embarked upon will be completed. There will be back and forth, give and take. Both parties will have counsel. There will be concessions that are made. For example, the case I was just talking about where the groom has the family business interest. Well, the representative, the attorney representing the bride in my example might say, well, hold on a second. My client is going to be living a certain lifestyle based upon this business interest. If all of a sudden her husband dies and now her lifestyle has to change significantly, how do I protect my client? And in many cases, we have alternative ways of doing that. For example, life insurance is an excellent way to fill a gap where there would otherwise be an inheritance. Or there may be other provisions, that things that are done during life where the surviving spouse will have built up some cash reserves, some investment reserves to put him or her in a position where, yes, you're not going to get that inheritance, but in fact, you still will be okay.
I find, and I know you and I have worked together with both of our departments, the matrimonial department and your department, on prenuptial agreements. And, don't you find it's this really delicate balance you have to reach as to how to negotiate something aggressively without saying, you're marrying a jerk, don't marry him or don't marry her. And sometimes you feel like that, right? So when you get a proposal that says he should be written out of everything and there should be no alimony. By the way, parenthetically, we should let our audience know that any addressing of child support or custody in a prenuptial is not enforceable. I just want to mention that. But don't you find that sometimes when it gets contentious, you really want to say to somebody, why are you marrying this person? I have had the situation where I've written a letter to a client saying, this is not fair. I will not recommend you enter into this. And in fact, I can't represent you because it's so one side.
Pat, you and I have had those cases before. I specifically remember one being presented to a bride 48 hours before the wedding while the whole family was on a plane coming over from India. And the bride was presented with the prenuptial agreement. And we told the bride, we will not represent you in this regard. Under no circumstances should you sign that agreement. And incidentally, it turns out that marriage didn't ultimately work out. We later came to find.
Yeah. It's important for our audience to know, just because a prenuptial agreement is signed shortly before the marriage does not make it unenforceable.
That's right. Specifically in New Jersey, the law was changed almost 10 years ago, where there is no provision in the law that says that if it's signed on the eve of the marriage that it's unenforceable. And in fact, there are provisions in New Jersey statute that says as long as you have fair disclosure or counsel or opportunity to have counsel, they are per se enforceable. So you've got to be really careful in a situation where you're signing it on the eve of marriage. If you think that, because I'm signing it on the eve of marriage, it's not going to be enforceable, that's not a risk you want to take.
And how about if it's not fair? Is it enforceable?
So again, in New Jersey, the fairness issue used to provide that determination of whether it was fair was made at the time of divorce. And now under the new law, whether it's fair is determined at the time of execution of the agreement. And so long as there is adequate disclosure, as long as there is opportunity to be represented by counsel or actual representation by counsel, it is by its very nature enforceable and not unconscionable. So you have to really be comfortable with this agreement if you're going to sign it. If you think that you're going to sign it, but it's not going to be enforceable, that is not a bet you should be taking.
So what I take away from this is that even though you could sign it the day before, and even though that could be interpreted as fair and it could be enforceable, you don't want to be in a position where you do that when your guests are waiting for your reception. Get this out of the way months and months before the wedding date, not because of its enforceability, but because the emotional toll it'll take, because there are very few people who would have the ability to cancel a big event. And there are very few people who get married. I always say this, nobody ever gets married thinking they're going to get divorced. So it really is smart, if you're thinking about a prenuptial agreement, months in advance, get it out of the way. It'll inevitably create conflict if you're negotiating close to your wedding, and it's going to be enforced.
Yeah, and if you and I have been in situations where we have told people to put off the wedding, and they have put off the wedding. So if you're going to have a prenup, get it out of the way early on.
Let's move forward. People get married. They don't have a prenuptial. It's a long-term marriage, not going real well. Kids are teenagers. One foot is out the door. In fact, I was thinking about it years ago, about 7 or 8 years ago, you and I wrote this article, Thoughts on Estate Planning When the Honeymoon is Over and After the Divorce. And it struck such a chord in so many people. We got a tremendous response. My question to you is, what do? You're still married. it's not going so great. Kids are older. You think I'll wait for them to get out of college. Is there planning you could do to plan for the end of the marriage? We always say people plan weddings, people plan marriages. They never plan divorces, which shocks me. But we unfortunately do some divorce planning.
Yeah. So, look, when the marriage isn't working out, it's not as if it's rare that it's working out on Monday and it's not working on Tuesday. There is a long, gradual decline in the success of the marriage. So, I think it's important that if you feel that your marriage is on a trajectory where it's not going to make it to the finish line, as it were, that you should be discussing these issues with an attorney. Obviously, you have no obligation to and probably should not tell your partner, your spouse, that you're going to see an attorney, but you should go see an attorney.
But what could you do? Because in New Jersey, for example, you're either married or you're not. There's no legal separation. What could you do? You're still married.
Well, you might start to arrange your affairs so that you put yourself in a better position in the event that you're going to go forward with a divorce. That might include certain estate planning that you do. You might be doing some planning to ensure that the children's tuition or higher education is taken care of. And you might make some investment decisions that are different than you would make if you were happily married.
There's nothing wrong with that ethically. I don't mean legally, ethically. I mean morally, I should say.
Even legally, ethically, I guess there are issues. If on the eve of divorce, you start moving assets and making gifts and transferring and what we call unilaterally dissipating assets, obviously that's a problem. And we would never give advice to that effect. But we might very well advise a client not to take assets that would otherwise be exempt from division in the divorce and to transfer those over to a joint account. For example, let's say the wife has inherited $1 million from her parents. And she and her husband have always wanted a beach house. The marriage isn't so great, but they really want this beach house. So all of a sudden, they decide they're going to take that $1 million and they'll buy a beach house. And they're going to put that beach house in joint name. Well, that's the kind of thing that would be a mistake. Because now what you've done is you've taken an asset that would be exempt from division, exempt from equitable distribution and divorce, and you've now commingled it. And you've now put, in my example, the husband's name on the house. And there's a very real risk that in a divorce, the husband will be awarded a portion of that house. Whereas if the wife, in my example, had kept it in her own separate name, then that would be protected in the event of a divorce. The likelihood of a division of that asset is extremely remote, barring certain circumstances. So that's the kind of advice that if a marriage was going south, an attorney would give to a client. Hey, look, if you're not sure this is going to work out, first and foremost, keep exempt assets exempt. Don't commingle them. Don't be making decisions that will convert exempt assets into equitably distributable assets. It may be an issue of whether or not you want to continue in your current job. Let's say you're in a job that doesn't make you happy and you're thinking about making a move to a job that might pay you less.
This is an issue I see a lot.
So you see it more than I do, but that might affect alimony if one spouse is going from a high-paying, unemotionally rewarding job to an emotionally rewarding job that doesn't pay very well.
So I see this a lot in my practice where marriage is maybe 25-year marriage. One of the spouses is about 60. They're not happy in their job and they want to change it, make a lot less money. So if you're making a lot less money for a period of time when you get divorced, that's the status quo. But if you're making the higher amount of money when you file for divorce, you're going to be stuck with that being imputed to you for determining alimony. So when you are in an unhappy marriage and your spouse says to you, oh, honey, I'll be happier if I have less pressure and make less money, warning sign, because that could be a setup to pay you less alimony going forward. Or another one I see very frequently, especially with COVID, the whole job world has changed dramatically, where somebody will be in a very high paying job at 63 and say, I think it's time for me to retire. They've been unhappy for a few years. The husband, at the risk of using traditional roles, says, yeah, I don't want to do this anymore. Maybe we'll be happier if I retire. The problem with that is that if he retires and he's not earning money a year later when the marriage ends, you're not going to get alimony. I mean, that's a very black and white statement. It's not meant to be, but you really have to pay attention to that stuff. That really concerns me.
Yeah, one of the other issues where I see this could possibly come up is with respect to life insurance. Let's say that the couple has been successful in getting their kids educated. They're coming to the end of their college years, and there's a life insurance policy. Maybe it's a permanent life insurance policy, maybe it's a term policy, but they've been paying it for many, many years, and they're getting tired of paying it, but the marriage is sort of going south. In that case, I might counsel the spouse who would otherwise be receiving alimony, do not let your spouse cancel that life insurance policy, because we may need that life insurance policy if you get divorced to secure an alimony obligation. So it's sort of an issue that you really wouldn't think of. You're just making a decision, hey, we don't want to keep this life insurance policy anymore. But if there are rough seas ahead, that's a time to sit down and talk to a lawyer so you understand what the issues are and you're making decisions with all of the information that you require, and that you're not making a decision in a vacuum.
Yeah, I've seen many people, unfortunately, make decisions in a vacuum or in a desperate attempt to keep their marriage. And ultimately, it's not a decision that's in their financial best interest. And it's sad because they realize they've been set up, for lack of a better word, and it's hard to recover from that.
It's oftentimes that a marriage ends where one spouse never saw it coming.
And by the way, that always surprises me when people say I'm in utter shock. But, when you ask them and you say, can you just talk to me about what's been going on, and you really dig, even they usually say, yeah, maybe I didn't want to see it, like all of us, right?
And while certainly we tell clients to have their guard up, when you're truly blindsided, there's really not much you can do.
And it could be financially devastating, which is the sad part. I also see situations where one spouse or the other isn't aware of where the money is.
Well, I haven't yet seen the case, but I suspect it's coming down the road quite shortly. With the significant growth of cryptocurrencies, I see a very easy way for one spouse to hide resources from another spouse. And with cryptocurrencies, it is very hard to track them. I don't know if you've seen this yet in a case, Pat, but I suspect we will shortly. And that is, it would be much easier for one spouse to hide assets from another spouse by the use of cryptocurrencies and also these NFTs, these non-fungible tokens, where all of these assets are sort of off the books. It would be very difficult to discover them through the ordinary discovery process of sending out subpoenas and getting bank records. So one of the things that any spouse who fears that the marriage might be going south, or that has suspicion that the other one is maybe sneaky or disingenuous, you might want to have your guard up for evidence of any sort of activity in the world of cryptocurrency.
So I haven't seen any actual cryptocurrency cases where the cryptocurrency has been located, but I do have a couple of cases where there is suspicion that investments are being made in cryptocurrency and is not traceable. I have, however, seen a lot of situations where one spouse, whether it be the husband or wife, relies upon the other to make investments, track money, track investments, and then they are surprised when they see that the investments were poor investments. They didn't get the advantage of the stock market bump that's happened, or they just thought they had more money than they had. I mean, I've had situations where people say, I thought our mortgage was paid off, and it wasn't. And it's sad because people trust each other, and you should be able to trust your spouse to make decisions that are in your best interests, but sometimes they don't. What's the lesson here, Gary?
Well, I'll tell you one lesson. Look at the joint tax return before you sign it.
Oh, how often does it happen that they don't?
Often.
Come on.
And keep a copy of it. It's not unusual for one spouse to be responsible for the tax filings, and the other spouse is just presented with the return and just signs it without looking at it. But there is a tremendous amount of information you can find out from a tax return. Now, I get it. Some people wouldn't even know what to look for in a tax return. But at least if you had your own copy of the tax return, you could go to your own advisor, whether it's an accountant, an attorney. Somebody could tell you, hey, look, why in 2018 were there dividends coming from an account at XYZ institution, and all of a sudden they're no longer coming in the next 3 years. So that's the sort of thing that if you are looking out for yourself, being a good steward of your own resources, you ought to be doing.
I mean, I see people who don't even have passwords to their accounts because, again, they're totally trusting. And it's not unusual in a marriage. As I said, one person's role is one thing and another's is another thing. So if you are in a situation where you don't even have the passwords to your accounts, that's a problem. Because you need to know where your money is. You need to know what you have. You need to understand your financial future so that if the marriage does end or your spouse dies, you are informed, because there's nothing more terrifying than walking into a black hole and not knowing what's going to happen. The other thing is that you spend a lot of money on lawyers like us finding out what you have, when if you come to us with that information, it's a much more meaningful experience.
Yeah, look, the simple answer is that the best way to protect yourself is to understand your own finances and not rely upon your spouse for all of that. You should ask questions, especially around tax time. Hey, where are our accounts? What do they look like? What do they consist of? Who's our advisor? Who's preparing our tax returns? Can I see the tax
Oh,
return?
it seems so unromantic to do all that, though, doesn't
Yeah,
it?
well, being responsible for your own financial well-being is not
Oy.
exactly romantic, but
No,
nonetheless,
it's not.
it's very important.
Well, it's like we talk about the prenuptial. Before you get married, in order to have an effective prenuptial, you have to have complete
That's right.
disclosure.
During the duration of the marriage, there wouldn't be full and fair disclosure.
Well, because you look at things like Gary. I'm not suggesting you're not a wonderfully romantic guy. We could call Susie and ask her. But the truth is, you're the kind of guy who is very pragmatic. I run a business with you and ask very practical questions. And that's a great thing. But a lot of people just don't have that skill set. Now, that's foreign to people like you and I. But a lot of people are afraid, or they feel like it's intrusive. There was a time where talking about money was a dirty topic.
It's not just in the event of a divorce. I mean, look, people die. I just lost a friend in his mid-50s. And it's important that even in a healthy, happy marriage, that both spouses are aware of family finances. And it might not be death of one party. Maybe one party becomes incapacitated, and suddenly the other partner, who was not primarily responsible for the financial resources of the family, is now thrown into a position where they have to be. Those issues need to be addressed.
During the marriage, and we're going to talk about after the marriage in a minute or two, but during the marriage, are there other documents that you should have in connection with your spouse that permit you to address things like disability or incapacity?
Every adult individual should have what's called a power of attorney.
Married or
not, even if you're, maybe even more so as a single person.
Well, what does that mean? What is the power of attorney? Doesn't that mean I'm letting somebody do anything? They could take all my money?
Well, it depends on the nature of the power of attorney you sign, but a power of attorney is a document which grants another individual the ability to act on your behalf with respect to your property and your property rights. Now, that's a lot of legal mumbo jumbo, but basically it means that somebody else can sign a check on your behalf. Somebody else can access your bank account, can buy and sell security.
I've been on my own for a long time now. I can't imagine ever letting anybody do that for me.
So in most cases, you could go through life and never need to effectuate that.
I would trust you, Gary Botwinick. I would trust you to do that for me, but we're business partners. It's different.
Well, in most cases, you would trust your spouse and or your children or your brother, your sister, your best friend to do those things. Everybody has at least one person, I'd like to think, that they would trust to handle those responsibilities. Look, in the absence of that document, it doesn't mean that nobody's going to have access to your assets. They are. If you become incapacitated and you do not have a power of attorney, you have not appointed what they call an attorney in fact, an agent to act on your behalf, then a court's going to do it in an expensive proceeding called a guardianship proceeding. But ultimately, somebody's going to have to act on your behalf. If it's me, I'd rather select that person myself. I would rather my family not have to go through the heartache of having to go to court. I would rather not have to be declared an incapacitated person.
Well, does it have to be your spouse? How about your spouse isn't good with
It could be anybody you want over the age of 18. I have had spouses that don't appoint each other, especially in second marriages. It's not unusual for a spouse to appoint a child from the first marriage who's an adult to act as the agent under a power of attorney. And keep in mind, basically, there's two categories of powers of attorney. There's one that's effective the moment it's signed, and there's one that's effective only in the event of a disability. Many people aren't comfortable with the one that's being, I signed it on Monday, it's effective immediately. Somebody on Tuesday could be signing checks on my behalf. They say, I only want it effective in the event of my disability. We refer to that as a springing power of attorney because it springs into action. So if you're uncomfortable, if you don't have somebody you fully trust, but you know that you need somebody, use a springing power of attorney. So if you're disabled, somebody can act on your behalf.
And how about other documents, just quickly, that maybe somebody should have if they're married or not married? Living will, we hear a lot about that.
So typically when I refer to a living will, I'm referring to two documents. One is a healthcare proxy. That's a document wherein you give somebody else to make medical decisions for you if you can't make decisions. That might include end-of-life decisions, the ability to make decisions as to whether or not life-sustaining treatment will be included or will be administered or not. Also, it's an advance directive where you yourself express what what your wishes are. If I'm terminally ill, permanently unconscious, I have no hope of recovery, I don't want to be kept alive artificially. Better you should be expressing your wishes than to leave that to somebody else who's going to have to decipher what your wishes would have been.
Well, if you don't choose somebody, is it automatically your spouse?
Typically, if you had not had a document that authorized somebody to make those decisions, then the next person in line would be a spouse. If there's no spouse, then a child.
I mean, I think that's a really important document because people feel philosophically so differently about staying alive that it really varies from person to person. So I think that's a really important choice personally.
Absolutely.
I mean, I was married to a physician, and with all due respect, I would not have wanted him to make the decision because he was so darn clinical about everything.
That's an issue that comes up often. Let's say there's 3 children of the marriage. One might be an emotional basket case. The other one might be too clinical, as you suggested. The other one has the right balance. So that's the one you would select to make those decisions.
So now we're looking at a situation where the marriage is over. It's done. Either they've been divorced or somebody died. But as you say, it always ends. Do you address new estate planning? Do you keep your old will? Do you address financial planning in a different way, or financial responsibility, or the legal issues surrounding money when the marriage is over?
Look, I think financial and estate planning matters ought to be addressed all the time. Constantly be thinking about what happens in advance of the marriage with prenups. We talk about being in a bad marriage during the marriage, what you do. So now let's say you're already divorced. You've just come out of a divorce. Look, the fact is, if you're in the midst of a divorce proceeding, you ought to be revisiting your estate planning documents. You ought to be writing a new will.
Why?
Well,
I left everything to my spouse and then to my kids.
So let's say you had a will that left everything to your spouse, and in the middle of the divorce proceeding, before there was any finality, you pass away. The will would govern, and the will would probably that left everything to the surviving spouse would be enforced. Now, that changes once you're divorced, because upon divorce, the will leaves to an ex-spouse is read as if that ex-spouse predeceased. So it's in the interim, during the divorce process, that there's concerns. And there are certain states where you cannot modify your estate planning documents without the consent of the other during the marriage. And there are states where you can. You have to revisit these items: wills, trusts, living wills, powers of attorney.
How about life insurance?
Absolutely, you should be revisiting life insurance.
And I find so often what happens when a marriage is over, the divorce decree is signed, more when there's a divorce and a death, people are so relieved that it's over that they forget about everything. It's as if they go blank. And I have seen many times, as have you, something comes back to haunt them when the other person dies. The life insurance wasn't changed, or when they die, their will wasn't changed.
Yeah, and look, there are several state statutes that provide for relief in those circumstances, but those state statutes don't necessarily govern all assets. There are assets that are governed by federal law. So while a state law might say that upon divorce, the former spouse is written out of the documents automatically, that's not the case with respect to benefits, employee benefits that are governed by federal law. So the best practice is to sit down after the divorce, immediately after the divorce, and revise everything.
So I have teenage children and I'm getting a divorce. I don't want my spouse to get my assets, but I want the kids to get my assets. And if I die, in effect, isn't my spouse getting the money because the kids are getting it? And isn't that always a conflict?
Well, it depends. So let's say you have minor children and you want to leave your divorce and you want to leave your estate to your minor children, which you likely have the ability to do. There is no need to leave it outright to that child. What would be a better idea would be to leave those assets in trust for that child or those children and designate somebody else to be the trustee. Let's say you have a brother or a sister or the aunt or the uncle of the children who would protect the interest of those children, so that when the other parent wants to use that kid's money for this, that, or the other thing, an obligation that the surviving parent would have otherwise had, they'd have to go to the trustee and say, hey, I need money for this. And the trustee would make the decision as to whether or not that should be the surviving parent's obligation or whether it should come out of the child's money.
This is a lot of information that we're sharing with our listeners. I think you and I could talk about this as we do for hours and hours. But for now, I want to thank you for being on Heartbreak and Hope. I look forward to many more conversations and sharing lots more information for our listeners to address how money could help heartbreak and encourage hope. Thank you for being with us, Gary. Thank you so much for joining us today. Don't forget to follow us on your favorite podcast platform. Please give us a 5-star rating and leave a review so more people can listen in to Heartbreak and Hope with Pat Barbarito.